This video is going to prepare you for the Wednesday oral argument before the United States Supreme Court in the Michael Cargill versus ATF case, which presents the question of whether or not a bump stock device somehow constitutes a machine gun as defined by federal law. This is a stretch to say the least, given the fact that bump stocks were viewed as not machine guns for many, many years by none other than the ATF. But then in 2018, they decided to do a course correction, a 180-degree change, and declare bump stocks were indeed machine guns. This was really a shocking turn of events, but the good news is, remember how I've taught you before, that sometimes bad news gives rise to good news? Well, this may be another example where a overreach by the anti-gun movement in America is going to backfire big time on them for many reasons. Stay tuned. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, so big argument on Wednesday, that's tomorrow, in the United States Supreme Court, Michael Cargill versus the ATF. Just to jog your memory, in 2018, after the Las Vegas shooting by Stephen Paddock involving bump stocks, allegedly, though I'm not ever sure that was entirely proven true. It's a little fuzzy as to whether or not he simply possessed bump stocks or actually used bump stocks. I'm not sure that's evidence has been made crystal clear, but let's set that issue aside. Bump stocks were certainly found in the room with a whole bunch of other guns that the shooter, Stephen Paddock, had used in Las Vegas during the Las Vegas shooting. This occurred during the Trump administration in 2018. And in 2018, the Trump administration basically came out and said that we're going to ban bump stocks. I think you can debate whether or not that was a good or bad move by the Trump administration, whether or not that nipped in the bud any potential statutory actions by Congress. I don't know, but you can have that discussion. But nevertheless, the bottom line is the Trump administration with the ATF went out there and declared that bump stocks were machine guns. Now, just to remind you, a machine gun is defined by federal law. It is part of the National Firearms Act. The National Firearms Act defines a machine gun as any weapon which shoots automatically more than one shot, without manually reloading by a single function of the trigger. That's a statute 28 U.S.C. 5845B. And the argument by the ATF back in 2018 was that, this is kind of interesting, we're going to get a little geeky here. What happened was the ATF did a notice and comment period waiting for comments about whether or not bump stocks were machine guns. Then what happened was they said they are machine guns. Then they go into court. And in defending this regulation, the ATF actually did not cite to Chevron, the Chevron doctrine of deference, which basically says that if there's any doubt or ambiguity or question marks as to what a statute means about what an agency like the ATF has authority over, then you defer, if you're a court, to the agency's interpretation. No, what happened was that the ATF took the position that this was not what's known as a legislative rule, which usually occurs after notice and a comment period and whatnot, like most regulations. They actually said, despite the fact they did that this was an interpretive rule. This was simply their interpretation of the NFA's definition of machine gun, that bump stock would fall within it. Now, this was a little game the ATF was playing because they're saying, look, this is just our opinion. But the problem is, and the courts of appeals noted this and said, look, it may be your interpretation, ATF, your interpretive rule, that a bump stock is a machine gun. But the reality is it has the effect of a legislative regulation. Why? Because given that that's your interpretation, if someone is found in possession of a bump stock after 2018, you're going to put them in prison, or at least you're going to prosecute them and try to put them in prison. So for all intents and purposes, the intent and the effect of this interpretive rule, which is just supposed to be, hey, this is how we interpret things, has the effect of being an actual law and really an amendment to federal law, because up until that point, a bump stock was not viewed as a machine gun until 2018. In fact, the ATF had previously said it was not a machine gun and was not an NFA item. So this is where the fight occurs. Michael Cargill had 2 bump stocks that he owned in April 2018. He relied upon the ATF's clear instruction that they were legal to use. And then, of course, what happened when the ATF did this, those bump stocks became illegal, and he sued using an organization that supported him, and good for them, the New Civil Liberties Alliance, that's the New Civil Liberties Alliance, brought this lawsuit alongside the plaintiff Michael Cargill, challenging this regulatory overreach by the ATF. At least that's the allegation. Now, some big picture historical items, and then we'll break down the lawsuit a little bit more and what to look for in front of the U.S. Supreme Court. Here's some of the big picture observations. The Cargill case is the first ever Supreme Court case that actually will get into what technically is a machine gun. So for those of you out there that like to say machine guns are protected by the Second Amendment, machine guns, that's great. But watch this case very carefully, because although this is not technically a Second Amendment case, it's a regulatory question of whether or not the ATF has overreached their statutory authority under the National Firearms Act. We do need to look carefully as how does the Supreme Court going to technically define or interpret the federal law that defines a machine gun. The U.S. Supreme Court has never actually weighed in on the technical issue of what is a machine gun. So this is going to be interesting to watch that alone. The second thing to keep in mind is that the Cargill case on Wednesday is the second time ever in U.S. Supreme Court history where the Supreme Court has ever even attempted to define any NFA firearm. The first time we saw this was in the case of the United States versus Thompson Center Arms, in which that case held, specifically that Supreme Court held, that the parts intended to be assembled as a rifle with a barrel over 16 inches do not constitute a rifle with a barrel under 16 inches unless actually assembled as such. It was a technical debate about some of the definition of an NFA firearm. The most important part to understand in the U.S. versus Thompson Center Firearms case is that the Supreme Court then found an ambiguity in the law. And then it says because there's an ambiguity in the law involving a potential crime where you could go to prison, because it's criminal in nature, it thus had to be construed in favor of the citizen under the doctrine of the rule of lenity. The rule of lenity is basically a tie goes to the runner in baseball, which says that if there's an ambiguity about how to interpret a federal statute or regulation where there's criminal implications, meaning you can go to prison, then the citizen wins. Any ambiguity is ruled in favor of the citizen against the government. Okay? It's like an insurance contract for those commercial litigators out there. Wherever there's ambiguity in an insurance contract, you rule against the insurance company in favor of the policyholder. The same idea with the rule of lenity. If it involves criminal applications or if it's criminal in nature in any respect, then any ambiguity associated with that law, that statute or regulation is basically interpreted in favor of the citizen over the government. Same idea here. That arises from the case of the United States versus Thompson Center Arms involving the National Firearms Act from about 15, 20 years ago. Okay? Now, what we want to look at going forward, in addition to the fact is how does the Supreme Court define a machine gun, is we want to also see how they describe a bump stock. Now, my concern in this case is, will the justices get confused about the mechanics of a bump stock device? Because the way it works is, again, as a reminder, a machine gun under the National Firearms Act is any weapon which shoots automatically more than one shot without manually reloading by a single function of the trigger. Now, a bump stock, as you know, and you guys are better at this than I am, I'm sure of it, but the firing of the rifle, produces obviously a recoil, and the trigger bumps repeatedly into the shooter's finger, firing it again, as long as, of course, there's forward pressure being maintained on the front grip. And this is the key. It's really bump firing, as you all know better than I can explain. It's really a manual technique. And if, for example, your non-shooting hand, which is on the foregrip, right, if that's not held in place, well, it's not going to bump fire. So it's not the device that's converting it into a machine gun. It's really a shooter's technique. And without that forward pressure, it's simply not going to fire repeatedly. And again, I think the Supreme Court's going to rule in our favor in a big way, because I think they're clearly going to say that a bump shot does not shoot automatically, or I should say a bump stock does not shoot automatically, because again, you have to maintain that forward pressure on the front grip. It doesn't simply shoot by a single function of the trigger, because the recoil is what makes the trigger move back and forth, and it's the finger must remain on the trigger device at the same time. Now, I should note that I'm not sure that the Cargill lawyers make this argument as clearly as they could have, but I think it's being made in various other amicus briefs and the like, but I think it's on the record sufficiently for the Supreme Court to understand that the bump stock is not a machine gun for many reasons, one of which is it's simply not by virtue of a shot, repeatedly shooting by a single function of the trigger. And keep in mind that the other powerful thing that's going on in favor of Michael Cargill's side is that the ATF classified, these non-mechanical bump stocks, which really, as not machine guns for many years, and then they flip sides and go the opposite route. I think that's going to be very powerful evidence. I think, justices like Justice Kavanaugh and Justice Barrett are not going to be thrilled with that ATF flip-flop in this particular way, especially when people can go to prison over this. And again, as the new Civil Liberties Alliance of Michael Cargill have pointed out, that this with the simply change of the regulatory interpretation, it instantly turned 500,000 people throughout the United States into criminals if they continue to possess the bump stock, and that's just absurd. So that's kind of the big summary here, but a couple other things to keep in mind we want to look carefully at. Number one, will the Supreme Court make reference to the Chevron doctrine? We know that the Chevron doctrine is on its last legs. It's likely going to go away forever with this term's decision in the Loper-Bright case, which deals with fees associated with fishermen on their boats and who should pay it. That case is almost certainly going to wipe out the Chevron deference doctrine, which technically speaking, if you're honest about it, should not apply to the bump stock case. The reason why the Chevron deference doctrine should not apply to the bump stock case is because it has criminal applications. And because it has criminal applications, the Chevron doctrine is not supposed to apply. Not supposed to apply. But of course, the ATF always likes to cite to it. They always like to talk about Chevron, but they're not going to be able to do this because the Loper-Bright case, I think, is going to wipe that out. So what the proper doctrine here is the rule of lenity, which we saw in, again, the United States versus Thompson Center Arms, which says that, again, any ambiguity is in favor of the citizen. To the extent there's any ambiguity about whether or not a bump stock is a machine gun, the ambiguity should be in favor of Michael Cargill and all the people that want to own bump stocks. The other thing, of course, is there's an ongoing, one thing about the Chief Justice John Roberts Court we can agree upon. There's a lot I can complain about, and I will complain about, and I have complained about. The one thing, though, we can generally agree on is when it comes to regulatory overreach by executive administrative agencies, the FDA, the EPA, and in this case, the ATF, this Supreme Court has been pretty aggressive in sort of shrinking the authority and scope of the powers of these regulatory agencies when they do not have a clear mandate from Congress. And again, as you know, Congress makes the laws, the president enforces the laws, the courts, Article 3 of the Constitution, interpret the laws. And what's been going on here is that all presidents, including President Trump and President Biden for sure, and certainly President Obama, have been trying to legislate through executive regulations so that, because there's a lot of this stuff like banning bump stocks was probably never going to be able to get through Congress, so they did it through the executive branch, just by waving a magic wand of the ATF. And this Supreme Court doesn't like that. So again, I think we're going to see in this ruling, I suspect what we're going to see is the ATF's going to suffer a massive loss. There'll be no reference to Chevron doctrine because that's going to go away. There will be discussion of the rule of lenity in our favor, and there will be, I think, a narrowing of the scope of what a machine gun is, so it does not include a bump stock. And I think that will all be overall very good news for the Second Amendment. But these are the sorts of things I'm going to be looking for. My greatest concern, again, is will the court understand the technical differences between the definition of a machine gun and, of course, what a bump stock is. And the last point to keep in mind, it will be interesting to see, is there any discussion of the National Shooting Sport Foundation's discussion of novel or new firearms technology? Because one of the points that the National Shooting Sports Foundation makes in their amicus brief is to say to the Supreme Court that the ATF should not be allowed to go out there and quash innovation through regulation. If there's something that Congress wants to ban, then Congress has to ban it. You can't turn it over to these unelected bureaucrats these sweaty civil servants in Washington, D.C. to make these decisions. So again, that's the other thing we'll be watching for. Is there any discussion of, what about new fangled firearms or new firearms technology? That'll be another thing we should be paying attention to see if there's any reference there. So there you have it. All right, folks. Well, hope this is a good preview of what's going to come on Wednesday. Don't forget to subscribe and resubscribe. People keep getting knocked off. We're trying to get to 150,000 subscribers and catch up with some of our other fellow gun tubers out there. But again, don't forget to follow me on X at 4Boxes Diner, and we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.